Good morning. My name is Tony Francois. I'm a senior attorney with the Pacific Legal Foundation, headquartered here in Sacramento. We represent John Duarte and his company, Duarte Nursery. John is a fourth-generation California farmer whom the federal government wants to fine $2.8 million for plowing his own company's farm. The Justice Department absurdly insists that this crushing penalty is justified by the Clean Water Act. But the Clean Water Act and its implementing regulations clearly state that plowing to produce a crop is not subject to Clean Water Act regulation, not a discharge in the technical terms of the Act. In other words, plowing does not require a permit from the Corps of Engineers under the Clean Water Act. This unprecedented abuse of the Clean Water Act to persecute a farmer for merely plowing, something the Act allows without a permit, should alarm every farmer and everyone engaged in agriculture in California and across America. The Justice Department is litigating this prosecution as a test case to eliminate the broad protections for farming that Congress, the people's representatives, included in the Clean Water Act. Congress understands that if the onerous, time-consuming, and expensive permitting requirements of the Clean Water Act are imposed on the nation's farmers, we will not long have an adequate food supply. John Duarte, his attorneys at Pacific Legal Foundation, and our co-counsel all strongly urge the administration to take a close look at the facts, the legal issues, and the implications of this case, and to assess it for what it really is, an abusive holdover of the last administration that really should be abandoned. Until that happens, though, we will continue to litigate aggressively on behalf of John Duarte and Duarte Nursery's rights. We are standing up for the rule of law and the protection of farmers and citizens everywhere, and will litigate these principles to the Supreme Court if necessary. I'd like to introduce our client, John Duarte.
Thank you, Tony, and thanks to the Pacific Legal Foundation for standing up aggressively for myself, my company, and farmers everywhere in America. If this prosecution is successful, it will destroy my company. We employ 500 people at Duarte Nursery. In Stanislaus County, where unemployment rates are high and jobs are desperately needed, as is with many parts of rural America. If these federal bureaucrats can come onto our property, establish for themselves that what we initially stated was true, we did not deep rip, our tillage was 4 to 7 inches deep, and the vernal pools and all wetland features are still existing today in a healthy, biological, intact state as though they existed through many wheat crops before the one we planted in 2012. The same government agencies can go on any farm in America and shake down the growers for what they're worth. The $2.8 million is not based on our environmental impact. The $2.8 million is a result of government financial accountants investigating my company and its financial statements, and me personally, and my assets, and deciding what they think we can pay. We can't pay $2.8 million. We can't pay the $20 or $30 million in addition to that these federal agencies want us to transfer over to the National Wetlands Foundation so they can put together wetland mitigation banks. This is an abuse of government authority. It's in the face of legislative limits, carefully constructed into a very good piece of legislation, the Clean Water Act. If those protections in the Clean Water Act can't stand and protect me now, they can't stand to protect any farmer in America. And the ability to construe new environmental legislation in the future to address future needs is gone. If we can't legislate with meaning that's durable and that protects citizens and farmers like myself, we can't legislate, period. This is a constitutional crisis, it's an abuse of government power, and it's a vindictive assault on my family and every farm family in America.